Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 7 and 8 on the speed of 90 words per minute. Start. The question involved in the appeal is as to the right of the appellant to verify the disability certificates issued by the medical board under the provisions of the Persons with Disabilities, Equal Opportunities, Protection of Rights and Full Participation Rules, 1996. The respondents applied for BTC training course under the physically handicapped category on the basis of certificates issued under the aforesaid rules. It was claimed that they completed the training and had been offered appointment in the primary schools run and managed by the state government. A complaint was received from Bharatiya Viklang Sangh of illegal usurpation of the quota reserved for handicapped persons on the basis of fraudulent procured certificate without suffering from the disability certified under the rules of 1996. The state government issued an order dated 3/11/2009 making a provision for constitution of fresh medical board in order to verify and assess the disability of the candidates. The candidates questioned communication dated 15/7/2010 issued by the Director, State Council for Educational Research and Training based upon the GO dated 3/11/2009 requiring them to appear before the medical board constituted in order to assess the disability. Out of the 234 candidates selected under the handicapped category on being examined by the medical board, it was found that 21% of the candidates were not handicapped. A single bench of the High Court of Allahabad wide judgment and order dated 31/8/2010 dismissed the writ application holding that under the rule framed in exercise of the powers under subsections 1 and 2 of section 73 of Persons with Disabilities, Equal Opportunities, Protection of Rights and Full Participation Act 1995, the general eligibility to apply for facilities, concessions and benefits admissible under the scheme of the Act is subject to such conditions as the state government may impose, and the state government has imposed condition in the order dated 3/11/2009 of Constitution of the Medical Board for verification of the disability. Even otherwise, under the rules, there can be a review of the decision upon representation by the applicant and fresh order can be passed. Thus, the certificate issued is not final. On appeal being preferred, a division bench of the High Court of Allahabad by the impugned order has allowed the appeal and has held that while the certificate has been issued in accordance with the rules of 1996, roving inquiry cannot be made until and unless fraud has been detected. It is not permissible to reopen medical certification carried out under the rules of 1996. However, the High Court has directed that a physical verification may be made, and if the candidate has not been issued certificate of disability or otherwise, or that he does not suffer from any disability so certified which entitles him to such a certificate, in the event the candidate can be subjected to fresh medical test. Accordingly, the directions by the government in the order dated 3/11/2009 and by the director on 15/7/2010 for physical verification be construed in the aforesaid manner. What the respondent had done by filing the writ petition was to highlight grave irregularities committed by the Western Regional Committee of NCTE in granting recognition to private institutions who did not fulfill the mandatory conditions relating to financial resources, accommodation, library, laboratory, and other physical infrastructure, and qualified staff and admitted students who had either not passed the entrance test or had not appeared for the centralized counseling conducted under the directions issued by the state government. The respondent derived support from the orders passed by the High Court in various cases. The statement made by Shri Rajiv Singh, Member Secretary NCTE, who appeared before this court on 21/7/2010, that effective steps have been taken after discovery of irregularities in the grant of recognition to various private colleges in the state of Madhya Pradesh and other states falling within the western region, also gives credence to the respondent's assertion that all was not well with the Western Regional Committee. In the pleadings filed before this court, the appellants have not suggested that the respondents had filed the writ petition to settle score with any institution or with some ulterior motive. Learned counsel for the appellants also did not make any such argument. Therefore, it cannot be said that the High Court committed error by entertaining the writ petition and ordering an inquiry into the allegations of irregularities committed in the matter of recognition and affiliation of self-financed private institutions and admission of the students by such institutions. If the High Court had not ordered re-scrutiny of the recognition or affiliation granted to the private institutions, the irregularities committed by Western Regional Committee may never have seen the light of the day, and we do not see any reason to nullify the exercise undertaken by the High Court to ensure that the provisions of the 1993 Act and regulations thereunder are strictly followed by the authorities entrusted with the task of granting recognition and affiliation to the institutions and colleges engaged in conducting teacher training courses. The next question, which merits consideration, is whether the impugned order is contrary to the rules of natural justice, that is, audi alteram partem. In this context, It is apposite to note that in the impugned order, the High Court has not discussed eligibility or entitlement of any particular institution to get recognition or affiliation. What High Court has done is to interpret the relevant statutory provisions in the light of the judgments of this court and orders passed by it in other writ petitions. After examining the provisions of the 1993 Act and the regulations, the High Court held that subsection 3 of section 14 and clauses of regulation 7 and 8 of the regulations are mandatory and that recognition can be granted to an institution intending to undertake teacher training course only if the mandatory conditions are fulfilled. The High Court also held that the examining body cannot grant affiliation to any institution unless it is recognized by the NCTE.